Good morning, Judge. I'm approaching on Jaime Estrada.
Okay.
He's here for a termination of PPI. The SOP, he said he's paid all the fees, but we're still waiting to receive a certificate.
Are you ready? Did you receive word that he's paid everything as well?
Yeah. So the only thing about that, I've emailed it to Brenda. We are waiting on progress report from the CSO. As for an update, I've not received anything.
Okay, so do you have anywhere else to go?
I do have to run to ERD. What time does docket usually end?
But 12:30-ish.
Okay.
You know, I mean, today's a light day, so maybe 12. I don't know, we haven't gotten word. I guess we could roll it to tomorrow to see.
Yeah, I was just gonna say that if we, if I come back and we're still waiting, if we roll it, can we waive him just because he's here today? And
Does he have a receipt that he's paid?
I can
Have you asked him? Yeah, see if he, because they're gonna give him a receipt anytime you pay, you know? He should have a receipt.
Let me follow up.
Yeah, see that, and then so that we know that he actually did pay, and then assuming that he did, then yeah, we'll waive tomorrow.
Okay.
Judge, can we, deal with the open boards?
Oh, come up, Mr. Lestrade. Let's do this. I'm not going to do anything until this lawyer gets here. All I know is he's got 3 open cases. They're all at 7503 because you continually take off. You come to court when you want to come to court. You don't come to court.
People say don't come to court. He told my the probation.
Let's wait for your lawyer to get here and we'll see. But all I know is you've got 3 open cases. All the bonds are 7503, which indicates to me that you've taken off 3 different times.
No.
So let's see. So just take a seat for me.
Come to court for.
I mean, I'm not going to argue with you. I'm going to wait for your lawyer to get here and then we'll go from there.
Okay.
But you're supposed to come to court when the reset says, not when you want to come to court.
No, he told me not to come to court, Judge. He said not.
You can come to court, right? But you're supposed to come to court when the reset says. And we have multiple instances of you not doing that.
Okay.
I mean, I don't know how else to say it. So let's wait for your lawyer to get here and we'll go from there.
Okay.
Let's take a seat.
Judge, I already emailed him because he got one of the.
He got another new one, so hopefully and he's usually pretty good about showing up. So. Right. Ready? How are you? You know. Who do you want to talk about first?
Let's do a strap.
Okay. Come up, Mr. Lestrade.
So Judge, there was misunderstanding on this case. So on his older cases, his appearance was waived. He wasn't required to come to court. It's when they did the new 2B on the new case, which I believe is beer and a bag of candy. And so that's when I tried to contact him to get him to come in, couldn't get in contact with him, then he had to schedule a court date for the old cases, and that's when the court revoked his bond based on those old cases. He said he received a letter, so he came in today to address the letter, obviously, and that's why he's here today.
So let's do probable cause on your newest case, because I don't know anything about it. Mr. Lestrap, you've now picked up a third theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched to a Walgreens in Harris County, Texas, and the complainant, the manager of the Walgreens, told officers that the defendant entered the store and proceeded to take several items, including a case of beer and a large pack of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees knew the defendant by name and sight.
Where is the trespass and the theft, the prior trespass and the prior theft? Can you tell me where those are?
They are also at a Walgreens. Let me see if it's the same location. It's the same location.
I told you when you first came here not to go back to the Walgreens. Not once, but twice. What should I do now, Mr. Lestrap? What should I do? You tell me.
Judge, just for the court's knowledge, my client is homeless. He doesn't have a place to stay, no employment, has some assistance from his mom, but obviously that's not a whole lot. That's the number.
That mom over there?
I'm not sure.
No, it's not. She at home.
Did you come with mom today?
No, sir. She at home.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat.
Yes, sir.
But how on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to.
Mississippi court once, maybe. Missed twice? Judges remember. This isn't about calendars. This is about trust. When a defendant skips court, judges don't just see an absence, they see disrespect. And in court, trust is currency. No trust means no bond, no leniency, no second chances. Now here's where it gets complicated. This defendant didn't miss court just once. He missed again. Then came the excuse. I couldn't show up. I broke my leg. Sounds serious, right? But here's the detail no one expected. The injury happened while he was running from police. Now
You're not getting it.
Can we at least address the bond, though, Judge? Because I believe the bond's at.
Absolutely happy to. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Okay, done. But the revolving door closes today.
Yes, sir.
It goes with you. I'm with you though. 500.
Appreciate it.
We're saying the bond's ultimate.
I will. Good morning, gentlemen. You are Mr. Lowry. You must be Mr. Benson then. All right, gentlemen, both of you have picked up criminal cases, and it looks like you've worked out an agreement with the state and your defense lawyer. It looks like both of you, Mr. Benson, are charged with theft, and you're facing up to 6 months in jail and or a $2,000 fine. And Mr. Lowry, you were charged with criminal trespass as well. You're facing up to 6 months in jail and or a $2,000 fine. The agreement you have worked out, Mr. Benson, is 22 days in jail, credit for the 22 days so that you are done today. You need to understand that this is an enhanceable offense. If you continue to pick up theft cases, at some point they're going to hit you with a felony, and instead of days, you will be looking at years. From now on, you are now facing a minimum of 30 days in jail. Do you understand? Mr. Lowry, with your criminal trespass, they've offered you 122 days in jail with credit for the 122 days that you've done. So likewise, you're also done with us today as well. It will go on your record. You can never take it off. And from now on, you're facing a minimum of 30 days in jail. Do you understand? Is this what both of you want to do?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, there's no turning back. It will go on your record. It'll stay there forever. How do you plead to the offense, Mr. Benson? I'm going to find you guilty. I will follow the agreement, send you to it. Mr. Lowry,
Yes, sir.
how do you plead to the offense? Guilty or not guilty? All right. I'm going to find you guilty as well. I'm going to, if any enhancements, just abandon it.
On the.
Oh, do we need to do it on the
Well, there's
theft?
one with the second conviction. on
Got it.
theft.
All right. So, Mr. Benson, you have a prior theft from 2019. Is this true?
Yes, sir.
Okay. This now makes two. A third, you're looking at a felony charge. No matter if it's a pack of gum, a big pack of candy, be careful. You could be facing some serious time next time. You understand? Okay, so true to the friends. We'll abandon the other one. All right, good luck, gentlemen. Thanks.
All right, gentlemen. Go ahead.
Oh, and Mr. Benson, your second case will be dismissed. I didn't realize you had it. Oh,
I was told I needed approach on Mr. McCullum. He's not here today. I don't know.
we have quite the, did you represent him before?
No.
Okay, we have quite the history with this gentleman
Okay.
where he's had a couple cases in here with numerous bond violations. He pled not too long ago, or no, I think did it get dismissed or did he plead? I
I
don't know.
think one of them pled and the other one got dismissed.
So he's now picked up a new case. All I know is that he's charged with evading arrest. He picked up a new case on the 30th. And we've gotten letters, or I'm sorry, emails stating that because of this case, I think he like broke his leg in half, is what he's saying. He broke his knees, tibia, fibia. I don't know.
Okay.
He's provided Victoria some kind of paperwork. I don't know if it's legitimate or not. It appears to be, but I was going to do probable cause number one to see, was there really an injury that occurred? I don't
It
know.
says he tripped and fell. The officer indicated that he tripped and fell as he was running.
Mind,
Yes.
please.
On December 29th, 2024, an officer observed another officer driving through a parking lot of 2901 West Ridge Street with emergency equipment on and chirping sirens due to a large crowd loitering on the property with no loitering signs. The officer observed in the left side mirror the defendant toss an object underneath a motor vehicle on the property. The officer made a U-turn and observed the defendant reaching under the same motor vehicle, retrieve the object, and reach into his front waistband as if placing the object. The defendant then tossed the object under another motor vehicle. The officer wearing full uniform told the defendant to come towards him and asked what he had dropped. The defendant walked towards the officer, stating he did not drop anything. The officer grabbed the defendant's left hand and attempted to handcuff, and the defendant took off on foot. The officer chased the defendant, and the defendant tripped on a drainage. The defendant evaded for approximately 100 feet. The officer looked underneath the motor vehicle and retrieved an unholstered black Glock. The defendant was identified by his Texas driver's license.
Did he suffer an injury as a result of that trip and fall? Does the officer notate? Because from what the email says is that he went to the hospital at that time.
It's not just an injury. It's a question. Was it bad luck? Or another attempt to buy time? The courtroom goes quiet. The judge pauses. Because excuses don't erase patterns, and patterns matter more than stories. Every missed court date leaves a mark. So here's the real question. Should repeat no-shows get another chance? Or are they playing the system? At what point does sympathy turn into accountability? You've heard the excuse. You've seen how this goes sideways. Now tell us, is the court right to be skeptical? Or does injury change everything? Drop your opinion in the comments.
Leg injury. He was taken in an ambulance.
Let's say that.
Yes, Judge.
Okay. So I've appointed you to represent him. If you don't mind reaching out to him to see how bad is it? When can we get him here? How? And we'll go from there.
I did see he has felony on the 30th, so I'll see if I can get in contact with him and find out if he's going to come to that, and if so, we'll just do it the same day.
Yeah, I'm okay with that. Okay.
Right now, Blake's email address.
Okay, great.
Okay, perfect.
That way you can, now, one more thing. In the past, he has also emailed me with a bunch of stuff before. So when you reach out to him,
Communicate
Don't-
or anything.
don't call me, don't email. It's been quite, just please.
Yes, sir.
Yeah, okay.
Are we given, because you said you wanted to about the hospital. So you're saying he's 9 here on the night.
Okay.
Do you want Friday or?
I think that's it. I think we're done. What?
There's some places that are falling wrong.
Oh, on,
Approbation and which is overstretching more. See, I'm not sure. Garrett is one of them. This is Ray.
yeah, I remember. You said Garrett?
Iman.
I'm on.
For Stovall.
I mean, unless,
Yeah.
all right, Mr. Lestrap, it looks like you've worked out an agreement. Come on up. I really hope that you heard what I said to you earlier. Every time you go to this Walgreens, they know who you are, every single person. So every time you come back, what do you think they're going to do? They're going to watch you like a hawk. Your every single move. You've been trespassed from there. So if you go back there and they call the cops, you're going to be right back in jail. Don't go back. You've worked out an agreement. They're offering you 60 days in jail with credit for the 2 days that you've done on this theft case here. Looks like they're going to dismiss the 2 other thefts that you have. You also need to understand this now makes at least 2 thefts for you. You pick up another theft, you're going to be looking at a felony charge, years instead of days.
Yeah.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. Are you sure you want to do this? Guess that's it, right?
Yes, Your Honor. I talked to him. He understands the nature of the consequences.
Okay.
Has no means of being able to afford bond, so we can look at the newer case. So he's opted to take the agreement on the old case.
If you can't ever make bond, if you don't have anyone in this life that's going to bond you out, then why pick up a criminal case? You know what I mean? When you leave here, Mr. Lestrap, come back. If you want a place to sleep, if you want a job, if you want food, I'll give it to you. All you got to do is come back. But if you keep picking up criminal cases, no more PR bonds. Do you understand? There's no excuse. We will give you resources. All you got to do is come back. You're giving up the right to, have I gone through the warnings? I don't remember. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, there's no turning back. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty and I will sentence you to 60 days in jail. I will give you credit for the 2 days that you've done. It's not enhanced, right?
I think there are any enhancements.
Okay.
No enhancements.
All right. All right. Hi, good luck. Or did he say plead guilty?
Yes, sir.
I didn't hear it.
How do you plead to the offense, sir? Guilty or not guilty? All right. I'll find you guilty, sentence you to good luck. Thank you so much, Ray. Hi, come on. Yes, ma'am.
I'm here on Raymond Henderson.
You said Peterson?
Henderson.
Henderson. Okay.
I'm here trying to work on a plea deal. I just wanted to know if the court would be willing to give him time or credit for the time that he served out of county before he was extradited here.
Sure, of course. Yeah, I mean, it's young though, isn't it?
I think he's
No. The case,
Oh,
the case.
Yeah.
It's only,
Sorry.
right?
Yes, it's a newer case. He's got about 17 days of credit built up from out of county, and then he also has some credit here in Harris County.
Okay. What offers have you given?
So we gave a 30-day offer, so we're expecting that with the credit to be time served.
Okay. Yeah, I'm down for sure.
Thank you.
Yes, ma'am. Thanks.